Good morning, everybody. Welcome to the First District Court of Appeals. We have 3 cases on the docket to be argued today. I'm going to call each case. If counsel could introduce yourself and indicate your readiness to proceed. First case is State v. Rodriguez. Okay. Next case is State v. Britton.
Well, Your Honor, Carl Lewis on behalf of Jasmine Britton. Good morning, Charles.
Morning.
Sean Allen on behalf of the state.
Morning, Mr. Allen. And then the final case to be argued is Texlo v. Gator Hillcrest.
Good morning, Your Honor. Susan Argo, on behalf of Braden and Texlo. We are ready to proceed.
Okay.
Lana Johnson on behalf of Gator, we're ready.
Okay, thank you. Thank you all. Everyone will have 15 minutes per side to argue. I will keep your time. The light system will indicate green means go, yellow means you got about a minute left, and red means your time's expired. With that, we'll have the first case, State v. Rodriguez. Ms. Conklin, would you like any rebuttal time?
Yes, 5 minutes. Please.
5 minutes, very well. And you may proceed when you're ready.
Elizabeth Conklin on behalf of the appellant, Amy Rodriguez. May it please the court, counsel. Our appellate brief sets forth 2 assignments of error. However, both of them are premised on the same argument, that the failure to provide the jury with the necessary information that linked the allegations of child endangerment to the counts in the indictment failed to provide her an adequate remedy on appeal. And so our first assignment of error is the plain error of the trial court. Under revised.
But is that, I guess, I understand like the due process type argument that you're making, but does the error ultimately, is there anything in the record to show that the error ultimately prejudices the client as to the outcome as compared to due process challenges?
If Amy Rodriguez had been convicted of all 11 counts, I don't think we'd be here. But she was found not guilty of 7, guilty of 4. The problem we have is there's no way for me to determine, or for anyone to determine, what underlying conduct served as the basis for the convictions.
Well, let me ask you this, ma'am. When the prosecuting witness testified, his testimony sort of followed the state's Exhibit 2, which is, I think they call it the trauma timeline. And they explained that when things happen, kids don't really remember them chronologically. But the prosecutor seemed to walk the prosecuting witness right through each one of these counts, right? And then in closing argument, she argued that this was count 1, 2 through 11. Am I correct in that?
The problem is that there was, in closing arguments are not evidence.
Right, but
And
you're
so-
allowed to argue what you believe the facts have shown.
Absolutely, but what she didn't argue what the complaining witness said established that this conduct was affiliated with count 1, this conduct was affiliated with count 2, and we know that because the jury had no idea which conduct went with each count. They came back twice asking for information that would help them identify what underlying conduct was related to each count in the indictment.
Let me ask you this then, ma'am. If the judge were to say, okay, well, count 1 is child restraints used in public, count 2, beaten with belt till legs bled, wouldn't that be error? Isn't the judge making judicial fact-finding if she tells the jury that those acts that this kid described apply to each one of these particular counts? I mean, that would be error, I think.
Well, there's actually a case in Ohio that we've cited in our reply brief, State versus Amos from the 7th District, that said that providing the jury, in response to a jury question, the information that allowed them to identify what conduct was affiliated with what count was not error.
Let me ask you this then. Sorry. The defense was, this never happened. It wasn't like it happened, but it wasn't as bad as described. The defense was, the kid's not credible. It just didn't happen. All right, so how could a judge say, well, this conduct, again, just say the beaten with the belt applies to this count, when the defense is it didn't happen?
Well, correct, but those are the allegations. And so for the jury to understand and be able to provide a meaningful review of the evidence, it had to know which conduct that was alleged to have occurred was associated with each count.
But are you suggesting that in all cases where there are multiple counts involving multiple offenses like this, that the jury instructions have to provide explanation as to what the allegations are tied to that count? I guess I'm just trying to understand how far would the rule that you're advocating go?
Well, I think in this case where you had an indictment that listed 7 counts and the indictment language was identical in each of the counts. Many times when you have a drug case or a murder case, there's a specific piece of information in each count that sets forth, like to wit, cocaine, to wit, marijuana, to wit, shooting the person during the course of a forcible felony. Those pieces of information provide the factual basis for the verdicts in those cases. In this case, I think where you have multiple allegations of child endangerment, it's not that the issue wasn't necessarily did it happen, but did the prosecution prove beyond a reasonable doubt that it constituted child endangerment? And so when you don't have anything, either a verdict form that says, as you know, Judge Winkler mentioned, tethered to bed or stood in a circle or withheld food, that has been upheld as reasonable and not a violation of the defendant's rights. And that's all that the judge needed to do, was put in parentheses on the verdict form something that identified the count to the conduct.
Let me ask you this then, ma'am. Are we to take anything, from the fact that the jury found your client not guilty of 7 of the 11 counts? In other words, how can we say that by not answering the question, the jury lost its way when they said she's not guilty of 7 out of 11 counts?
Well, but I didn't argue that they lost their way.
Okay.
I just said you can't rely on their judgments because we have no idea what they found her guilty of. I mean, how would I argue manifest weight? I have no idea. Looking at the indictment, looking at the evidence, looking at the jury instructions, looking at the verdict forms, what conduct served as the basis for those acquittals and what conduct served as the basis for those convictions?
So if we were to reverse, since you can't tell, she couldn't be retried under double jeopardy because
Correct.
So she just discharged then, right?
Correct. I mean, if you reverse and remand for new trial, she will be tried for at least 7 allegations that she was found not guilty of. We just don't know what they were.
Can I ask about State's Exhibit 2? So was State's Exhibit 2, this is the
chart?
the chart, was this admitted into evidence?
No.
It was not
No.
admitted?
These are not, this was a demonstrative exhibit. And the
Oh, so
thing
it
is-
was put up during the child's testimony?
Yes.
And
he
then-
testified to it, but it was not admitted into evidence.
And do we know whether when the prosecutor did the closing argument, were they referring to this chart?
No, not to my knowledge. Because she just said, count 1 relates to this conduct, count 2 relates to this conduct relates to count 2. And as I cited, and the judge instructed the jury, closing arguments are not evidence. So even if she provided this information to the jury, 1, they obviously didn't hear it because they kept asking for the information that she'd already provided. And 2, even if they did listen to it and use that as a basis for their decision-making, it's not evidence, and they can't rely on that for their verdicts.
So even if the prosecutor put up a chart that said count 1 equals this, count 2 equals this, in closing, you're saying that wouldn't be good enough?
Correct. And I think that, perhaps you're referring to this court's decision in White,
Right.
where there was some reference to a big poster. From the decision itself, I have no idea whether that was actually an exhibit or just a demonstrative exhibit. But the difference between White and this case is, 1, White was convicted on all 17 counts. Two, White was arguing in his insufficient evidence argument that there was no way to determine whether there's juror unanimity. We're not arguing juror unanimity. We're arguing that there was a reviewability problem, and that's why those cases are distinguishable.
Well, isn't part of the problem here that we don't know if the jurors were unanimous and which act constituted which count?
I don't know. They all signed the verdict forms. I think, you can presume that there was negotiations or discussions about which counts we're going to find her guilty of, but frankly, it sounds like, we're just going to find her guilty of 1, 3, 5, and 7, and not guilty of all the other ones.
But was there, in the instructions, I didn't see it, but I could have missed it, any instruction that to inform the jury that it must unanimously agree on the specific act that formed the basis for each count?
No, there was no such instruction. And I think partially because it was, I don't know what the rationale was. It's an error to not have, there's usually in the indictment, and I'm not saying that the indictment was flawed, it wasn't for purposes of constitutional notice, but it was flawed from the standpoint of connecting it to the verdict forms. So there were multiple solutions that could have been.
Is there anything on the record that gives us any idea why, after the second jury question, this wasn't remedied?
No, there was no discussion on the record. You mean among the
Yeah,
counsel?
I mean, there were two jury questions saying that the jury was confused.
Right.
And after the second, or even the first, do we have anything in the record that explains to us why they didn't attempt to unconfuse the jury?
There is nothing in the record.
Okay.
I'm sorry,
Okay.
did the, and I think I know the answer to the question, did the defense counsel ask the judge to say, Judge, all right, these acts, instruct the jury that these acts apply to these particular counts, even though it didn't happen? There was no request like that?
Correct, and that's why we've had to argue plain error, and that's why we've argued ineffective assistance of counsel as our second assignment of error.
Ms. Conklin, you're at your turn.
Okay,
Thank you.
thank you, Your Honors.
Morning, Mr. Souter.
Good morning, Your Honors. May it please the court, in answer to the last question that was asked, defense counsel explicitly declined to have a further instruction. This is on transcript page 3159. After the second question, the defense counsel said that there was no need for it, and there was did not want to have a further.
Mr. Souter, I'm just, I got to be honest, I'm just really struggling with this case because I think Ms. Conklin has a point that we don't know what she was actually convicted of. And I appreciate her inability to mount a sufficiency or manifest weight challenge as I look at this record. And the only thing that I see that provides any guidance is the prosecutor's closing argument. But even that is it's pretty thin. It's just like rat-a-tat-tat, go through all of these. And I just how do we know what conduct she was acquitted for and convicted for?
Well, with all due respect, Judge, I think that the prosecutor's closing argument did go into pretty much detail concerning what the which count related to which conduct. I mean, there wasn't a complete recitation of every fact that was underlying.
I mean, most of these are just like a sentence, maybe two.
Well, but it's referenced with reference to the evidence that was heard by the jury already.
Put yourself in the position of a jury, right? You've heard all this testimony, all these acts. Someone's going through it for the first time in closing argument in pretty quick fashion. You don't have the transcript of that closing argument back in the jury room. And what do you have to guide you? And one of them, the prosecutor even tripped up on count 7. I think it's inadequate clothing, no, it's food or whatever. And how's the jury supposed to remember that when they're back in the?
Well, first of all, I think that there was reference, even though that there was only demonstrative evidence, there was reference during closing argument to the chart. It wasn't point by point. But I think,
But the chart doesn't have any of the counts listed on it, right?
well, no, but it was a timeline,
Sure.
and the prosecutor made reference to, she even said, I apologize that this isn't in chronological order, but here are the counts. And I think we have to.
Can we tell if the chart was the chart up in front of the jury as a demonstrative aid?
At some point it was, yeah. I don't
But
know
not
if it- I
during
don't know if it-
closing?
I don't know if it was during closing or not. I can't tell from the record. But I think we, you know, and one of the things that Judge Winkler pointed out is that in this case, we do have split verdicts. And I think it does the jury a certain injustice to say that they just rolled the dice and said that, you know, we're gonna find her not guilty on all the odd number counts, or find her not guilty on all the even counts, or something like that. I think we have to presume that the jury fulfilled its oath to follow the evidence. And I think that there's enough here to indicate what the specific conduct was for each count. It's, and when we look at the exhibit and the prosecutor's argument together, I don't know how a specific jury instruction would have gone into more detail than that.
I mean, it
I mean,
could
it
be
could-
pretty easy. You'd say like, this is the count about the ballot, this is the count about the food. I mean,
Yeah, but there'd been so much discussion about these counts that it was possible for the prosecutor to refer in kind of a shorthand way as to what, you know, this is the part where he had to stand with his hands against the wall. So, I mean, or this is the part where he had to, where he didn't have adequate, you know, he didn't have enough to eat. So, I think that I think the jury was able to parse that out and was able to determine which count related, which conduct related to which count.
but I think that like, but the fact that the jury asked not once but twice suggests that they were really struggling with this exact issue.
And the fact that they asked twice and that didn't ask a third time, when, if we're going to presume.
They
that-
asked twice and got the same answer.
we're
Why
gonna-
would you ask a
but-
third time?
I'm sorry, Judge, I didn't mean to talk.
No.
But if they were truly at odds, or they were truly at their wits' end about what conduct related to which count, I think what they would have done, given the fact that they weren't shy about asking the court what was going on, I think what the jury could have said is, we can't come to a conclusion about this because you haven't answered our question. But what they did was parse out the evidence, parse out the allegations, and come to contradictory or not inconsistent, I don't want to go there, but not guilty on some and guilty on others, I'll put it that way. And I think that it indicates that once the court instructed them that you have to rely on your memory about this, that they were able to piece it together and come to a unanimous decision on all of these counts. And I don't see really any significant distinction between this case and State v. White. I think I think they're on all fours, and I think that the fact that in this case there were acquittals on some counts actually militates more in favor of an affirmance in this case than it did in
Well,
White.
let me ask you this, like, if we agreed with Ms. Conkin and reversed this case and remanded for a new trial on 4 counts, how would the defendant be retried on those 4 counts?
Well, I mean, I would, my argument would be, it would be with reference to what the allegations were at trial, with reference to what.
Allegations of what?
Of what the prosecutor alleged the specific counts were, and the demonstrative evidence that linked to the specific conduct to the counts. I would say that that's how, but I just.
But so just to be clear, there's nothing in the record, anywhere in the record, bill of particulars or anything, that links a specific count to a specific conduct other than the closing argument. Is that the only place, or is there anywhere else?
No, I suppose that's it. I suppose that's it. But again, it's no different from State v. White in that
Yeah,
regard.
sure.
So I'm just trying to understand your argument. Are you saying, do you agree that the jury instructions were based on the case law that requires if there's multiple counts alleging different acts, my understanding of the case law is that the jury instructions need to indicate which count goes to which act. Would you agree that that's the law?
Yeah, I would, actually, Judge, on the basis of State v. White, which is from this court just 3 years ago, I would say that that's not the law. I mean, it's certainly not plain error to not have that, because in State v. White, there were 17 counts of child endangering
Yeah.
with no specific jury instructions, and those were affirmed on appeal. So I don't see that there's a bright line rule requiring a specific jury instruction, especially when defense counsel specifically declines to have that given to the jury.
So I guess what we would take out of what you're arguing is that even if the jury instructions don't specify, that the prosecutor's closing argument can cure any defect.
And I think that was the indication in State v. White, and that was one of the things, Ms. Conkin calls it dicta, but that's one of the things that this court relied on, was the prosecutor's statements about what the evidence demonstrated. And I think that we have just as clear an indication in this case as we did in State v. White.
Now, how do you get around, I know the appellant relied a lot on Harp versus Kentucky, which you didn't really address in your brief, but Harp relied on a U.S. Supreme Court case, Taylor versus Kentucky, which says that a trial court's failure to give a jury instruction on the presumption of innocence was not cured by the defense counsel arguing the presumption in opening and closing. And so it sounds like what the U.S. Supreme Court is saying is that the closing argument wouldn't cure a defective jury instruction.
With all due respect, Judge, I think this court's found otherwise. I don't know that would be a matter of federal precedent, but it's more of this court didn't address any of the Missouri or Kentucky cases when it rendered State v. White, but I think that the consideration was there.
In the second district, are you familiar with the Shaw case out of the second district?
I am, Judge.
And how do you distinguish that case?
Well, I don't think we do. I think that there might be a conflict between the districts. I think that State v. White, in its clear indication that the instructions were sufficient here, there's just a difference of opinion.
So Shaw, you would agree that Shaw would say that the prosecutor's closing argument could not cure the problem in this case?
I would, yes, I would,
Okay.
but at the same time, I would say that State v. White reached the exact opposite determination.
Let me ask you this. So I'm reading from the prosecutor's closing argument. Count 8 is being hit with a spoon and a belt. That's count 8 and 9. He was hit with a spoon and a belt many times. Like, the prosecutor is basically saying the same conduct is covered by count 8 and count 9.
I think that the prosecutor meant, with respect to that, was like 8 would be the belt, 9 would be the spoon. I think she means that it's
Right, but that's not
I-
what she said. And I think like this gets back to the point, if the only place where there's clarification is the closing arguments, and people trip up, they misspeak in closing argument, it's not clean and polished like it is on TV. I'm just trying to understand like what guidance the jury actually had here, and that's what I'm struggling with.
I would just say that the specificity with which the Bill of Particulars set forth the argument, maybe with not specific reference to each count, but I think I just think from the entirety of this record, it's clear that what the counts that related to each.
Did the jury have the Bill of Particulars?
I don't know, Judge, probably not. I wouldn't
Okay.
think so. I wouldn't think so. It's as part of the due process inquiry, though, one of the questions is whether the defense on the whole had an indication of what conduct related to each count, and I think that there's no doubt in this case that what the allegations were. If the court has no further questions, I just ask the court to affirm the judgment of the trial court.
Thank you. Ms. Cochran, you have 5 minutes.
Do any of the justices or judges have questions for me?
The only thing I would say is that my reading of the state's closing argument was, when I read it, the prosecutor said, "You've seen this before." And then I'm like, what have they seen before? And then she went right down the list that follows this. So I can only conclude that this was, once again, being demonstrated to the jury.
Again, though, the jury's not allowed to consider anything other than exhibits that were actually admitted into evidence and the testimony of the witnesses in their deliberations. So, I mean, these are demonstrative exhibits. The closing argument, as Judge Krause pointed out, Taylor versus Kentucky, specifically a United States Supreme Court case, specifically says arguments of counsel cannot substitute for instructions by the court. So even if the prosecution had gone through and written down count 1, belt, count 2, spoon, count 3, tethered to the bed, it still is not evidence. And it's still not enough to cure the defective jury forms, verdict forms that they were given. And this is, the fact that they ultimately came to a conclusion can only, it is not evidence that they had all of a sudden figured out from nothing what conduct went with what count. It didn't change the fact that no information was provided to the jury. And from the standpoint of, to address your question earlier, Judge Winkler, in our reply brief on page 7, I specifically address the fact that courts in Ohio have held that verdict captions can be used, are commonly used, to identify what conduct goes with what counts in situations like this. And the fact that that was not taken advantage of by either suggestion by the defense counsel or primarily at the discretion of the trial judge, who has an obligation to provide the jury with the information it needs in order to render a verdict, we would ask that you sustain our assignments of error and reverse these convictions and discharge her from all counts of the indictment.
Can I ask on the, so with regard to plain error,
Yes.
so we're looking at whether the defendant's substantial rights were affected, and typically this is an outcome determinative inquiry, and I know it kind of goes back to a prior question, but maybe you can just articulate again this piece of the plain error standard. How is this outcome determinative? Do we have to look at whether it was outcome determinative?
Our argument for prejudice is that, I'll just read it, Amy lost all means to an effective appeal. There's no way to determine, as Judge Bergeron acknowledged during his questions of counsel, there's no way to determine.
Right, but I think what Judge Cross is getting at is there's a difference between you don't have an effective appeal versus you had a compelling, defense on the merits, and this prejudiced you on the verdict that was issued.
Well, I think part of the problem is there's no way for me to argue or anyone to argue that the convictions were against the manifest weight of the evidence or whether they were insufficient, based on insufficient evidence, because I don't know what counts she was found guilty of in terms of the conduct underlying those counts. If I can't argue those upon those bases, either manifest weight or insufficient evidence, then she's precluded from having an effective remedy. And even if you were to throw out the convictions and retry her, again, the remedy is that she would be retried in likelihood for 7 allegations of conduct for which she was found not guilty. And I think the cases that I've cited.
Is that for us to decide here, or would it be that we could reverse for a new trial and then you make your double jeopardy argument below?
I think it can be decided here. I mean, you're remanding something for a new trial knowing that is an impossibility. She can't be retried for 7 counts, but we don't know what those 7 counts of conduct were. So I'm asking that not only that you sustain our assignments of error, that you vacate the convictions, and that you discharge her from all charges against her in the indictment.
All right, thank you, Ms. Cohn.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out of 10-minute decision. Hope you both have a great day. All right, next case is State versus Britain. Morning. Mr. Lewis, how much time would you like for rebuttal?
5 minutes.
5 minutes. Okay, you may proceed when you're ready.
May it please the court. Judge Bergeron, Judge Winkler, Judge Cross, Mr. Donovan. I am respectfully moving through our appeal that the convictions of Desmond Britton be reversed on the 2 assignments of errors that we have advanced. The first being the conviction must be reversed as the trial court did not properly advise Mr. Britton of his right to compulsory process. And while I don't argue today that our first assignment error does not have strong merit, I believe the second assignment of error encompasses the first one and is the basis of our appeal, and that is the trial court erred when it denied Mr. Britton's pre-sentence Rule 32.1 motion to withdraw his plea. As set forth in the memorandum, I believe that as we did the research, I say we, was a team effort with my colleagues, the criminal rule 11C colloquy, I kind of glanced over just as the court did. We routinely in trial court go through the perfunctory stages of, do you understand the plea? Do you understand what you signed? And it's critical that an individual understands each and every element is set forth in the law, and that as you have the right of compulsory process to subpoena witnesses, not just that you can bring a witness.
Let me ask you this, Mr.
Yes, sir.
Lewis. I know you represent many criminal defendants. Do you think it's more meaningful to during the colloquy to tell somebody they have the right to compulsory process and then just move on? Or do you think maybe it's better to say your attorney could obtain witnesses on your behalf at trial? And the reason I ask you that is because when I was going through Rule 11, it said you have the right to compulsory process. Usually the question was, what is that? Right? So this judge said, your attorney could obtain witnesses to testify on your behalf at trial, and you're saying that's not good enough.
Your Honor, I would argue that, again, based upon your experience as a trial court judge, you understand that we have to follow the rules that are given to us, and Rule 11C has to be followed. The case precedent has stated that if the colloquy does not follow the letter of the law, that is, tell the individual you have a right to compulsory process, not just bring in witnesses. It's a twofold answer, if I could. As a trial attorney, I would understand that most of our clients probably wouldn't understand this, but it does not take away from the argument that the law requires the judge, the trial, to follow the rules, whether it's with respect to Rule 11C, whether it's any other part of the plea colloquy, it has to be followed, and it's there for a reason so that an individual can understand completely, knowingly, voluntarily, and intelligently what they're doing. Most individuals believe, well, couldn't I have my friend come testify? Well, yeah, you could, but he doesn't want to come today. Well, the Rule 11C in the law says we will compel them to come.
Well, how do you distinguish the State versus Barker case, where the Ohio Supreme Court has said that a judge saying you have the right to call witnesses on your behalf was good enough?
Well, I think our memorandum laid it out very clearly. I like the analogy. You're not called to the military if you're being commanded to, you're summoned or ordered to appear. You can call a witness to the stand. If that individual is not in the courtroom, then how do we get them here? And routinely, the state of Ohio will do a forthwith. And you can't do a forthwith if they've not been summoned and compelled to appear. So merely to call an individual in the colloquy is not sufficient to comport with Rule 11C. So I don't think call in and of itself.
But the Supreme Court said it was in conjunction with the written plea.
Yes, call as opposed to obtain.
Correct.
So I believe that the distinction is you have the right to subpoena an individual, you have a right to call that individual, but just the fact that you have the right to get witnesses is not sufficient under Rule 11C.
So you think call and obtain mean two different things?
I do.
Okay.
I do.
But what about using the word obtain in conjunction with, as Barker allows, looking at the plea agreement? Because, right, the written plea can be used to determine whether the defendant understands.
I don't disagree with that wholeheartedly. And if that were the case, then our pleas would be a lot quicker. If you could just say, did you read the plea form? Did your lawyer go over with you? Do you understand it? Let's go forward. Case law has shown that's not sufficient.
Right, but then the judge here also said you can obtain witnesses to testify. So I'm just asking if the two of those together would be substantial compliance.
I don't believe so, Your Honor. And again, no disrespect, but I grabbed my phone. I had pulled up Rule 11C to address that issue. I felt that question would come. And in Rule 11C, if I could, for the court, informing the defendant and terminating that the defendant understands that the plea by the defendant is waiving the rights, et cetera. And we get to the point of, I think this is where Judge Allen was going, to have compulsory process for obtaining witnesses in the defendant's favor. So I believe she was paraphrasing Rule 11C, but the rules require that you correctly state it, and I don't believe that call or obtain are the same, even in conjunction with the plea agreement, because that's read to by counsel, and it's not read word for word in court, as you very well know with your experience, Your Honor. A judge does not read each and every line of the plea agreement, and we believe that the defense counsel has gone over it, but Rule 11C and the case law requires that the judge stick to and adhere to the colloquy, and I believe using the word obtain in conjunction with a plea agreement does not cure it. If there's another question with respect to the first assignment of error?
I have a question about the second one.
Yes, sir.
And I know you've gone over this with your client, but if we were to agree that the motion to withdraw the plea should have been granted, your
Yes, sir.
client understands he's looking at two major drug offender specifications, which I think carry 10 years apiece. So if he gets what he asked for, that might not be so great, right, for him?
Your Honor,
I know you're a great defense attorney. Maybe he's not guilty.
to this esteemed panel, there is the law that we apply to the facts, and then there's the reality of life. My client understands that he has a right to be before the court and enter a plea knowingly, voluntarily, intelligently, without pressure. The end game, if you will, if in fact this reversal, if the court sustains our arguments and grants the reversal, would require more work at the trial level to get a resolution. Could that resolution be worse than it is? Yes, but I don't think that's for the court's purview. I think the issue is whether or not he was pressured into entering the plea.
And so that's your primary basis, as I understand it, for withdrawing the plea, is the inappropriate pressure to enter into the plea agreement. Is that right?
I would agree with that, Your Honor, but not that being the only argument. My concern is that under Rule 32.1, and the leading case is State v. XIE or Z or Zi, however it's pronounced, Your Honor, that prior to sentencing, while not an absolute right, it should be liberally granted. And in my 34 years of practice, I've not seen a more time-appropriate motion and no prejudice to the state to grant this request, whether or not he felt pressured, whether or not he meets the 9 elements, and does he have a strong defense. And I do take issue with that, with the 9th issue of whether are you guilty or not guilty. That's for your trial counsel to address. Yes, the pressure was extremely strong. I'm sorry, Your Honor, if I'm cutting you off.
No, that was what I was interested, because that's where I'm getting a little bit hung up on this, because I think usually you see in these motions to withdraw saying, you know what, I felt pressured, I actually have a defense. You don't delay the defense out, but you can say, I'm not guilty, I didn't do this, I've talked to my counsel, I have a defense to this, I want to go to trial.
Yes.
And this wasn't said.
To answer both questions, and the
Yeah.
point well raised, Your Honor, yes, the pressure was tremendous. When you have an individual, and again, I go back to your extensive trial experience, standing with his fiance, has a great job, and you're telling me I've got to make the decision now, or the state is going to revoke my bond, not just move the court. And the reality, as Judge Winkler just stated, when an individual is faced with a more severe penalty if he gets what he's asking for, the reality is Mr. Britton was well aware that he was not going home if he did not enter the plea. Not that the state might seek a revocation bond, not that the state was going to ask, revocation was apparent. So his plea was not done intelligently. With respect to the 9th point of you need to state emphatically, I'm not guilty. Well, you've already pled guilty. Now you're asking the court to withdraw the plea because I felt pressured, and maybe I do have a strong defense, but I haven't addressed that issue with my counsel because at the time I was retained, it was strictly for the purpose of withdrawing the plea and assessing the case. We had 30 days, if you will, or 60 days, I think we went to April, before we actually had the sentencing, and the hearing on the motion was going to be held the day of the sentencing or the day before. There very well could be, but his only concern was I want to give the right answer because I was told I get locked up. And if I give the wrong answer again today, I'm going to get locked up. Yes, he emphatically believes he's not guilty and has a defense, and I agree with the court that that has to be stated. But the question for us is, do we lay out our defense? Will a trial judge say to us at the time, you're required to tell me, since you're saying you're not guilty, why do you believe you're not guilty? And that was the fear as we laid out our memorandum.
I don't think that's the law, though. I think that it's just one factor to consider,
Yes.
because normally you would say, I felt pressured, but I want to go to trial. I want to exercise my right to trial because I believe I have a defense. You don't have to lay your defense out.
With this panel, if you would, in your memorandum, whether you sustain it or overrule it, would help clear that up, because the trial counsel believes that we have to go, as you stated, far close enough to say we want the Rule 32.1 motion granted, and we feel we have a strong defense. Our concern is, will some trial judge says you failed to lay out on the record what your defense is, now go to the Court of Appeals, and the Court of Appeals then tells us you didn't have to do that, so maybe we can cure that issue today.
Well, but I think if you represent to the court that you have a defense, that I would assume that court would accept that. Not so much your client, but if you're officer of the court, and if you make that representation, that I think that would be good enough. You don't have to lay out the defense, just say that you have one.
Well, again, I believe that if you look at the transcript and also the memorandum, Mr. Britton was on the stand when queried by the state, sir, do you believe you have a defense? He's not an attorney. He was thinking, I'm on the stand. I have to be limited in what I say because my lawyers told me be careful what you say. He was being as honest as he could, and at this point, he wanted Judge Allen to know, the trial court to know, I was pressured. So clearly, if we didn't meet that ninth component or the element, then we concede that he didn't lay that out clearly. But I believe that there are other factors that have been met, and clearly the timing prior to sentencing is appropriate.
And Mr. Lewis, you're at your time if you want
Thank
to
you, Your
reserve
Honor.
5. Great, thank you.
Morning, Your Honors.
Morning, Mr. Allen.
I guess I'll work in reverse order since we ended speaking about the voluntariness of the plea and that argument there. It's very clear in the trial court in making its decision specifically found that the basis for wanting to withdraw was to get a more favorable sentence. When he said, I felt pressured, I want to get less time. I felt pressured, I want to get less time. At no point in time did Mr. Britton ever assert any sort of defense to this. And I think this also incorporates the compulsory service aspect and the prejudice aspect there is that at no point is there any discussion about, I have witnesses that could come in. I have anything, I have a defense to this.
Is that required? I mean, it's one of the many factors in the Fish case, but is it always required in withdrawing the motion for withdrawal of a plea that the defendant at least say I have a defense?
I don't believe that it would be always necessary, any one of the factors, because we've got 9 factors. So if it's completely silent as to that, but the other 8 factors, weigh heavily in his favor, then I would say that it's harmless, that there is no discussion about that. And if the other factors overcome that, then it wouldn't be necessary. However, in a situation like this, there has to be something in the record that says it. Otherwise, it's just completely speculative, and in every single case, they can just remain silent, and then later on down the line, when nobody has an opportunity to respond, can say, I had this defense. Had that been raised, had the defense been raised at the trial court level, and the prosecutor spoke a little bit about that. The defendant
But is there a problem with the defendant who pleads guilty, wants to withdraw the guilty plea, doesn't necessarily want to go to trial, just thinks that, and it may be irrationally, but thinks he's going to get a better deal? If they otherwise meet the criteria for withdrawing the guilty plea. Is there anything wrong with that?
If the trial court, I mean, the case law says, wanting, I can bring it up, but just wanting more favorable terms is not a valid reason. Having buyer's remorse on the agreed plea that you worked out is not a legitimate basis for granting it, and the court doesn't have to do that. Certainly courts have done that in the past and everything like that. And this would go towards, Judge Winkler, you had made the comment about the NBO spec charge. It would actually be a mandatory 11 years, but the additional thing that would come into play is that there was a separate indictment and a separate case number that was dismissed per part of that plea. So all of those charges would additionally be revived were this to be, the plea to be invalidated and sent back. So I would say that it's certainly within the court's discretion to deny it if they feel that the sole basis for it is buyer's remorse. And the court made clear in its entry it did not find his statements that he was pressured credible, and that the court found that it was because of it was a negotiating tactic. And I think support can be found in that, in the fact that they want to talk about he was pressured on the day, he was pressured on the day, he was pressured on the day. This case had been out there for 8 months. He got indicted 8 months before the plea was, there had been discussions.
He was out the whole time?
I would have to check. I don't believe he was out the entire time, because there is reference in the record to jail calls, and I don't have that specifically in my procedural posture as to whether, so I wouldn't want to mislead. I believe he was in for at least a portion of the time, but that's not definitively established in the record, and we don't have the transcripts from all of those previous occasions. The other thing that we don't have in the transcript is any discussion about why sentencing was going to be set out for so long on an agreed plea, why he had a reasonable expectation that when he's pleading and agreeing to go to prison for 8 years, why he didn't think he was going to go that day, why it was put so much extreme pressure on him that the state was going to ask to revoke his bond that day if he didn't plead and agree to do 8 years. You're agreeing to do 8 years. I don't understand how that's extreme pressure and how that qualifies to
The
it.
judge here, so I think you said something significant, because when we're talking about voluntariness of a plea, certainly feeling pressured or being threatened that your bond's going to be revoked could potentially be a reason to allow somebody to withdraw the plea. In this case, though, the judge specifically made a credibility finding that he didn't believe him.
Yes,
Right.
ma'am.
Okay.
And so I think and I'm not saying that it could never be
Right.
pressure, and that it couldn't even necessarily be extreme pressure. However, in this case, I think the record supports that the motivation was not the pressure, and it doesn't establish why a motion to revoke bond would be any more pressuring than agreeing to do 8 years in prison. And so that's the point that I was trying to make, not that it would never be, but that in this particular instance, I don't believe that it was. I'd like to touch on a little bit on the colloquy and obtain. As I pointed out in my briefs, this court has had the word, that same phraseology in other cases where it was not directly the issue, but it did not occasion comment, where the court had mentioned obtain. And to go back to Judge Winkler's point about obtain being a terminology that more people are familiar with than compulsory process. And that would be something that you would have to explain to 90% of the population, and to say you have a right to obtain witnesses, and then, which is certainly more ambiguous as to invoking compulsory process than you have the right to bring in witnesses. In the second district, in a different decision, it said that the right to bring in witnesses, while adequate, is less than ideal, and we should strive for better than that. I think obtain, mirroring the language, if not the complete language of that clause in Criminal Rule 11, at the very least, invokes ambiguity into what obtain actually means. What do you mean by obtain? You have a right to obtain something. And so what does that mean? And so then once we have ambiguity, then Barker comes into play, and we can look towards the written plea agreement in which it is blatantly spelled out exactly and uses the precise language from Criminal Rule 11. I think I've touched on all the bases that I wish to touch on if there are no further questions.
Great, thank you.
Thank you very much.
All right, Mr. Lewis, you have 5 minutes.
First, are there any questions from any of the judges? And I believe that my 5 minutes will be a quick 1 minute. I draw the court's attention to page 11 of our memorandum in asking that the court sustain our issues that we've raised and reverse the conviction. Second sentence of the first paragraph, here the prosecutor candidly conceded that there would be no prejudice to the state. And then the second paragraph, the totality of the circumstances, whether we meet all 9 of the factors or 1, 2, or 3, or 4, the totality suggests, along with the colloquy deficiency, would comport and argue and support our argument, Your Honor, that the conviction should be reversed, remanded to the court for further activity. And with that, I have nothing more unless there are other questions.
What do we do with the judge's credibility finding? He found your client to not be credible when he said he felt pressured.
I don't believe this honorable court can really do anything with that.
We have to accept it, don't we?
You have to accept that judge's determination as subjectively. She viewed my client's testimony, but it's just one of the many factors that the court could consider, that she did not believe that he was pressured. But again, taking into consideration Rule 32.1 and the fact that prior to sentencing it should be liberally granted, as well as the fact that there's no prejudice to the state, and believing, Your Honor, that it was done in a fashion not 6 months later, 8 months later, immediately upon this plea, he sought out new counsel, and new counsel filed the motion the day after he was hired. So I would, in response to your question, I don't believe that we can do anything about that, Judge. Just taking into consideration your experience and knowledge, that I believe this is one of the most appropriate cases I've ever seen, notwithstanding the reality of what this young man might face if the court grants the relief sought here today, that the Rule 32.1 motion should have been granted.
And this is an abuse of discretion standard of review.
I don't know, Your Honor. Okay. That's a good question that I did not address. Okay. I don't, again, I'm always remiss to suggest that any judge I appear before has abused their discretion. I just believe that the court made a determination, but based upon the law that is before the court and the law that the court has handed down in the past, that our arguments that have been raised are sufficient for reversal.
Okay.
Thank you.
Thank you, Mr. Lewis.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision, and hope you both have a great day.
Have a great day.
All right, our final case for the morning is Texlo versus Gator Hillcrest. Ms. Johnson, you may come forward. Would you like to reserve any time for rebuttal?
Yes, please.
5 minutes, okay, very well. You may proceed when you're ready.
May it please the court. My name is Juana Johnson. I represent Gator in this case in its dispute with Texlo. This is a contract dispute. The lower court erred in finding that Gator was responsible to replace a card theft deterrence system that was never paid for or installed by Texlo.
Let me ask you this, ma'am. Wasn't there, I thought there was a bill of, not a bill of particulars, a bill of sale indicating the components contained within the store or sold to opposing the opposite client, but you say that's not good enough?
The bill of sale did not mention the
It
card
said
system.
among other things. Did it say that?
Sure. But here, what happened is this wire became a fixture. It was a wire that was installed around the perimeters, outside the building, under the pavement. That wire, once abandoned by Kroger, became the property of Gator, and it became part of the real property as a fixture. This is not a trade fixture. This is not a stove that could be removed and taken out, or a refrigerator that belonged to Kroger that would have been a trade fixture. This is a fixture that is now attached to the real estate and cannot be removed. Just because the transmitter was in the store, that doesn't make the entire system part a personal property or equipment. This is like saying, I have an air conditioning system with the air conditioner condensers up on the roof, but the thermostat is in the building. Well, because the tenant used the thermostat to control the temperature, that means the entire air conditioning system is now equipment that belongs to the tenant. That's not how fixtures attached to a real property.
But what about the fact that the tenant was making modifications or improvements to this system?
I'm not aware of the tenant making any modifications or improvements. I know that the wire was severed before this time, and that the tenant repaired the wire without informing the landlord, but I'm not aware of any improvements made to the system before having to replace it. I think it all boils down to the fact that the system was not installed by the tenant. The tenant did have the right to install its own system.
So the trial court disagreed with that and concluded that the usage essentially, and I'm paraphrasing, of the system equated to installation. So what is your response to that?
There's no basis for that. There is no fact that would support that finding. The trial court sympathized with the grocery store. I understand that, and it probably try to rule more in an equitable manner, but as a legal argument, the contract did not give the tenant ownership of the system.
I'm a little confused about the record. Maybe you can help me out.
Sure.
Because 6.14 of the lease agreement talks about installing a system. But there was already a system in place, right? Did the landlord not know that there was already a system in place? Because I'm confused on why 6.14 would talk about installation of a system if there was already one in place.
There was a system in place, but the landlord and the lease did not contemplate the tenant using that system. The lease contemplated the tenant installing its own system because the landlord did not know how well it functioned, how old that system was. The landlord was not transferring some equipment that it didn't know how it was going to function, well, or some fixture that could not be transferred according to the bill of sale or the lease.
Well, the landlord knew there was a system in place?
Yeah.
And the landlord was okay with the tenant using the system?
The landlord never gave permission or never was asked for permission to use that system. The landlord knew the system existed.
Okay.
But the tenant never asked the landlord, can I use your system?
Right?
This is a lease that was negotiated, and in the negotiations, the tenant was given the right to install a new
A
system,
new one?
but never asked permission. And the testimony is that the tenant never informed the landlord that they were using the old system.
But they didn't have to. I mean, the system just existed and the control box mechanism was inside the building, right?
That's the testimony.
And then they
yes.
spent money on upgrading the system throughout the years? Or
There's no
or
testimony to
maintaining
that.
it?
There's testimony that at some point, like I said, it was damaged, and the tenant made some repairs.
Okay.
But that's the only testimony. But also, the testimony is that they never notified the landlord that they were making repairs to this system. So the landlord still didn't know they were using an existing system.
But the landlord didn't care, right? I mean, there was no, you can't use the existing system.
There was no you can use it, or yes, you can use it. There was,
Okay.
the lease is silent as to whether the tenant could use the old system or not. But I think at the end, it doesn't make a difference because the tenant waived its rights to any damages arising from the destruction or damage to the system in two ways. There were two provisions in the original lease. The 7.2b is a waiver of all damages arising from a casualty or stemming from a casualty.
Right, but how is this a casualty? This is just like ordinary negligence where someone goes through, or maybe it's not even negligence, maybe it's intentional because they're ripping up the pavement and you have to, like, how is this a casualty?
Well, first of all, the landlord itself did not rip out the pavement.
Well, but they paid someone to rip it out.
Sure, they paid someone to rip it out in order to make repairs
Right,
to.
no, I understand that, but my question is, how is this a casualty? Like, this wasn't like a tree falls down and hits the place. This is someone's deliberately making an act by which this gets messed up.
Okay, well, but first of all, the landlord notified all tenants that this work was going to incur, so.
I know, but you're not answering my question, which is, how is this a casualty?
Well, this is well, first of all, the provision says whether the acts are intentional or not intentional on part of the landlord, the damages are waived. That's what the lease provision 7.2b states. Putting that aside, it's a casualty. It doesn't have to be non-intentional. It's a casualty. It's something that caused damage to a wire in this case, or some other object. That is a casualty.
I just think that your reading of that phrase is inconsistent with how it's so broad that it's inconsistent with your narrow reading of install.
But
If we're going to construe everything broadly and this is a casualty, then maybe what they did was install it.
okay, even if they installed it, it doesn't matter because they waived their, if we read it all broadly and consider that the tenant installed the system, then, and reading the waiver broadly, they waived their rights to any damages.
Ma'am, didn't Texlo let Gator know that that fence was there, and if they repaved, it was going to destroy their fence or their underground wire?
So what the testimony was at trial was that it was not worth removing the wire because installing a new wire would cost just as much as removing this wire to protect it. And so it was probably to the tenant's benefit to install its new wire. At the end of the day, this is the first time the tenant is installing a wire that is as permitted by the lease. This is not when the tenant comes in and installs the wire that they previously paid for. I mean, we're looking at something where the tenant is asking the landlord to pay for something they never paid for in the first place.
And Ms. Johnson, you're at your time if you still want to reserve 5 minutes.
Thank you.
Thank you. Ms. Argo, good morning.
Good morning, Your Honors. May it please the Court. Susan Argo of Bricker Graydon and my colleague Austin Ballrichter is with me today. I would like to just answer the question about the gatekeeper system and the installation. So this case is not about who installed it. What Judge Branch said is it's about under Section 6.4, who owned it and who had the right to use it as well. As to the
But you
installation.
only own it if you install it.
Well, the testimony is this, that Mr. Pearson, who is coming into a food desert, comes in and realizes the economics of opening up this Save-A-Lot store. At the time,
I mean,
he,
I hear that, but let's focus on the contractual language.
yes, and the contractual
and
language,
The contractual language says install. This was already there.
yes,
Help me understand how, in the English language, it means that you all installed it.
well, the entire case wasn't about installation. We came to own it later through the bill of sale.
Okay,
Mr.
so let me stop you there.
Yes,
So there's two ways that I see you potentially obtaining ownership. One is through the installation, and the
Correct.
second is through the bill of sale.
yes.
And so are you arguing that it's not through the installation, it's through the bill of sale?
Yes, Your Honor, we acknowledge
Okay.
this, that the entirety of the.
So then the judge was wrong about the installation.
She didn't say that they installed it. She said that this case is about who owns it and who uses it. And we went to trial about whether and when Texlo, this is her decision on motion for summary judgment, whether and
Well, but I'm
when
talking about her decision at trial. She says
Texlo
that you.
became the owner of the gatekeeper system. That's what the trial was about, is when did Texlo become the owner of the gatekeeper system? And then whether Gator's conduct or, damaged the gatekeeper system, breached the contract, and whether the damages to the gatekeeper system were general or consequential damages.
She did hold that the gatekeeper system was owned by Gator at the inception of the lease.
Yes, because under the section 6.4, so then, what happened was, Mr. Pearson asked to own it outright. And the tenant said, the landlord said, you have to build up goodwill as a tenant here, and then I will transfer the assets to you. And in 2018, a bill of sale was issued. It was known that gatekeeper
But the
system,
bill of sale.
the perimeter is in
The
the
bill of
lease.
sale does
Mhm.
not mention the gatekeeper system, and there's a whole paragraph in the contract about a system like this.
Mm-hmm.
So like, isn't that a deliberate omission from this bill of sale?
No, because of the including but not limited to, and what
But it's
Judge
fairly
Branch found is
specific.
that the transmitter, okay, so that wire is meaningless without the transmitter and without the carts on the system. It
Sure, I understand.
operates as a whole.
Understand?
And so when that bill of sale, including but not limited to, things inside the building, that is the transmitter, the wire is meaningless without the transmitter. It operates as an entirety of the system. The landlord damaged it two other times, the record is, and the tenant repaired it. And then he purposefully destroyed it. And for them to suggest that Mr. Pearson didn't notify the landlord is disingenuous. It's just flat out wrong. On July 10th, there's email between the tenant and the landlord saying, we have this gatekeeper system. What you need to appreciate is in this area, how important those carts are.
Yeah, I understand that. I want to go back to 6.14 because the trial court specifically held that Texlo was damaged by the breach of 6.14. So the trial court's wrong on that, right, according to your argument?
No, I'm not saying that they're wrong. No, because at
You-
the time,
I
okay.
just go back.
Okay.
I ask you whether it was a breach under 6.14 or the bill of sale, and you said it was the bill of sale, not 6.14.
No, you asked me how they came to own it, Your Honor, if I may. Under Section 6.14 then, at the time when the damage occurred, 6.14 is applicable by virtue of the bill of sale. The judge found that they owned it and had not only just ownership, it's not about who owned it, it's the exclusive right of use. There is designated common facilities, and the lease in Section 6.14 goes out of its way to describe even the tenant's absolute use of the perimeter
Only
and
something
further.
that they install.
Not installed. It says they have the right to install and use, and then,
Install and use.
the
They don't have the
gatekeeper
right
system.
to. Ms. Argo,
okay,
let me ask the questions, please.
okay.
Their right is to install in 6.14A a system, and after they install it, they can use it. So this then tumbles back to the question of, did they install this system? And that's my question. Did they install this system?
They did not install the system,
Okay.
but what the judge says is in interpreting section 6.14, it's not just about installation, Your Honor. It is about the right to own it and the right to use it. That was inherent. Every single grocery store from Kroger to Save-A-Lot to anyone that would come in there understand the importance of the gatekeeper system and carts to its business model. So what happened then after Texlo deeds it is in the lease. For the landlord to suggest that he didn't know that the gatekeeper system is there, the entire perimeter is an exhibit to the lease. It references it, it charts it out. And when the work was to be done, on July 10th of 21, 10 days before they came in, and 20 days before they actually, if they want to rely on this notice, they said the work was going to be done in August. It was done 10 days earlier. Thank goodness Mr. Pearson was out in front of it. He was reaching out to them in earnest to say, what's going to happen? What's going to happen to this? And it was dismissed outright. And then most importantly, as to this damage, I think Exhibit N is probably the most telling. The judge heard all of this testimony. Mr. Goldsmith himself said, there is no way you could avoid damaging that. None. He knew it, and he just ignored it. He didn't respond to Mr. Pearson. He didn't quite candidly care about it. And then he was brazen enough to say, we've made every argument.
I want to go back to the bill of sale point.
Yes.
So you own that, your client, under your theory, did not own the gatekeeper at inception of the lease, but owned it 4 years after the inception of the lease. Is that right?
It may have been even longer, Your Honor. I believe the lease is 2011, and then the bill of sale is 2018.
Okay,
So
I'm
to be
sorry.
honest, but yes, yes.
So your position is your client did not own it until the 2018 bill of sale?
Well, that's the most evidence. If you're going to read literally, yes. I mean, he came in and negotiated and said, it is imperative, I can't
Right.
afford.
I'm just
Yeah.
asking for your position.
Yes.
Is your position that you owned it in 2018 upon?
They were
consummation of
using
the
it, they
bill
were
of sale?
operating under section 6.14 in the common facilities, using the sign.
Right.
And yes, he was operating under his lease right.
But my question is it your position that your client did not own this until 2018? It's just yes or no?
Right. I guess at this point, the bill of sale made it very clear. I think that there's a question, but if we are saying that through the bill of sale, it was deeded to him. But during the entirety of it, the use of those premises, he wouldn't have come in and signed the lease if he was forced to install that gatekeeper system.
But so if this incident happened in 2017, then there would be no recourse, right? Because your client didn't own it until 2018.
I think there would be questions about their right to use it and displacement, but yes, to some extent, that's section 6.14, but what the judge has interpreted and said is it's not just, that lease provision isn't just about the ownership. It's getting to the heart of how important the gatekeeper system is and the use. It's like, she did try to investigate whether and when tenant Texlo became the owner, whether Gators,
But I guess I don't understand your argument about how important the gatekeeper system is under 6.14, because it only applies if there's an installation at your client's cost and expense. Obviously, if you all buy something and install it, you have the right to use it in accordance with this provision, but that didn't happen.
If you look at the time frame of when this happened in 21. So in 2018, this entire argument about ownership or not, it's very clear they owned it. It's very clear that they tried to bring this in earnest to this landlord's attention. It's very clear that the landlord ignored that request. They actually sit here and suggest that, we gave notice And under this Second Amendment, there's temporary, I mean, they have made every argument known to man that in 2018, that bill of sale transferred ownership, that tenant owned and operated a gatekeeper system that operates as an entire unit, that they damaged it. We have not gone as far as Your Honor might have suggested to say that it was with malice or they intentionally did it. But when Mr. Goldsmith at trial said, there's nothing you could have done, then why didn't he just take responsibility? He didn't. Instead, he just, comes up with every unique argument.
Right. I mean, you're just criticizing the witnesses. And I mean,
But
we're
that's-
focused
but
on
this- Yes.
But we're focused on the contract and who has what rights under the contract.
And I am focusing on that as well. I'm focusing on who owns it. So are you saying because a tenant didn't own property at the inception of a lease, and then later in the lease transaction where the landlord knowingly transfers property and then damages it with abandon, that's okay? I mean, Judge Branch asked, so are you saying that Mr. Goldsmith could set fire to the store and Section 7.2 would, exculpate, him? And she said no. The testimony.
So your bottom line argument is that bill of sale, it transferred this control panel, which was in the store. Everything in the store, right, was transferred over. And then necessarily that means the wire as well.
Yes.
That's your
It's
argument.
one unit.
Even though the wire was not in the store, the control panel was in the store. And the control panel doesn't work unless you have the wire.
Correct. And that bill of sale also says including but not limited to.
Right. And it, I mean,
you know.
and the gatekeeper system, according to you, is very, very important, but they didn't specify that in the bill of sale.
No, they did not.
Okay. But you're saying because the control panel was in the building,
He'd
the
been
wire
using
is a
it-
part of that?
Yes, he had been using it since 2011.
Okay.
It was very important. They maintained it. They treated it, they operated under it. You can see immediately, the gatekeeper system was severed and destroyed, and what ended up happening. Exactly what the gatekeeper was meant to stop. Carts just start running off, and that's very unfortunate. And so we asked the landlord, Texlo, the tenant, said, this is your responsibility, and tried to reach out. And then what's most telling is at one point, Gator says, yep, we'll take care of it. Even the bid under which Texlo ended up paying, if you look at Exhibit N, it says Gator, because even the installer of the gatekeeper system said they were contacted by Gator, and Gator's going to pay this invoice. And then the day before, he emails and says, no, we're not paying for it, and Mr. Pearson then is in a pickle, if you will, and, is forced to go ahead. I mean, it's very telling, and he's like, well, if they were going to pay for it, I have no choice at this point. It had gone on long enough. But at this point, this case isn't about the installation. This case is about ownership of a tenant and operating its business.
Based on that bill of sale,
Yes,
the bill of sale that includes the control panel, but doesn't specifically include
And then when-
wire.
correct.
Yeah.
And then when Judge Branch heard the testimony, she made a determination that the gatekeeper system operates as one unit. It's the locks on the cart, it's the perimeter wire, the transmitter, it's all one system, is the way that they operate. I think that's all that I have.
Okay,
then.
thank you.
Thank you for your questions.
All right. Ms. Johnson, you have 5 minutes.
Thank you. Couple of things. I don't, the testimony at trial, the evidence at trial doesn't show that the landlord damaged the system before this time. It shows that the system was damaged, that the tenant made some repairs, no improvements that we know of. But
Why can't we read the bill of sale, because it includes everything in the building? And there's a control panel for the system in the building that is useless without the wire. Why can't we read that bill of sale as transferring the system?
Well, for the same reason you can't read the bill of sale to transfer the air conditioners, or, because those are fixtures attached that cannot be, that transferred with the real estate. So just because there is some control unit in the building, like a switch to turn on the light in the common area, that doesn't make all the light fixtures in the common area part of the equipment inside. So the bill of sale is very specific in transferring the equipment inside. If anything were to be transferred from the outside of the store, it would have specifically been mentioned in the bill of sale, like the cards.
But would you agree that this control panel, which was inside the building, just the panel was transferred during the bill of sale?
If the panel was even there was disputed testimony at trial whether the transformer was even in the building at the time of that Texlo leased the space.
Oh, it wasn't established that this control panel was even in the building?
There's different testimony. I believe Mr. Goldsmith testified that the transmitter wasn't there. Mr. Pierce testified that it was there.
Okay.
I don't
Well,
see
if
in
it
the-
were in the building at the time of the bill of sale, would you agree that at least that piece of equipment was transferred?
That piece of equipment was transferred, but it wasn't damaged. So that piece of equipment did not need to be replaced. The wire needed to be replaced, obviously, because it was completely severed, but it wasn't transferred because, for example, the cards themselves. I know everybody is, or Ms. Argo argues that the cards are part of the system, but the testimony of a trial was that the cards were not used by Save-A-Lot. They were actually sold. The cards that were transferred as part of the bill of sale were sold by Save-A-Lot. They couldn't use it, they didn't use it. Those cards were specifically mentioned in the bill of sale because they were not inside the store. So if any piece of equipment outside of the store were to be transferred, it should have been in the bill of sale, which it was. The cards were specifically included because they were not inside the store. Also, Texlo was required to protect the equipment in the store with insurance. And Texlo never submitted a claim to its insurance company for any equipment inside the store because the wire was not inside the store. It wasn't equipment, and it wasn't transferred, like the court noticed, it wasn't transferred by its use. There's no evidence in the record or any law cited that would make this transfer because of the use. You can't just use something and then say, I used it for 10 years, therefore it's mine. There's no law cited in any brief, in any of Texlo's briefs throughout this entire case, or any testimony that would support that position. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.